comes part of the freedom of expression in 1918. And your lordships are very, very much familiar with the Puttu Swami's case, my lord. And my learned Professor Hegde as well, Mr. Justice Kamath, referred to the view of Justice Chalameshwar, in which he said that a right to believe also a part of the freedom of expression contained in under Article 1A, 19(1)A. That passage is read before your lordship. Now, having read that passage, my lord, I will also like to draw only one more paragraph from Puttu Swami's judgment. Now, the subject begins, concept and Manekan interplay between the rights. Your lordship has got that judgment, my lord, that 2017-10 SCC page 1. And therefore, my lord, the starts with paragraph 21, and I will not, my lord, read those paragraphs. And there they trace the history of the development of the entire theory of the interplay of those articles. And your lordship may directly come to the paragraph 24, by page 350. I will not read the whole paragraph, but only the relevant extracts from that paragraph, my lord. If your lordship may kindly see 1, 2, 3, 4, 5, 6. And the 7th line on the top of the paragraph, my lord. The jurisprudence foundation, your lordship got
paragraph number
24, my lord. 359. The jurisprudential foundation which held the field 63 years ago in MP Sharma and 50 years ago in Karak Singh has given way to what is now a settled position in constitutional law. Firstly, the fundamental rights emanate from the basic notions of liberty and dignity and the enumeration of some facets of liberty as distinctly projected rights under Article 19 does not denude Article 21. So not all the articles have to be read in conjunction with others, and one fundamental right reinforces the other. One doesn't denude the other. And it is expansive ambit. It is expansive ambit. Secondly, the validity of a law which infringes a fundamental right has to be tested not with reference to the object of state action, but on the basis of its effects on the guarantee of freedom. Now, your lordship will say that here the impact is important, not the object with which they are doing. What is important is that they want uniformity, they want discipline, but doing this, are you impacting the rights of the others and the rights of the petitioner or not? And here the impact is on my right of 25(1), freedom of expression, my right of expression 91A, my right to take education under Article 21. All this has to be sacrificed in the name of the so-called name of maintaining discipline in the court. Are there no other ways in which disciplines in the court can be maintained? Why are the Muslim girls who conscientiously believe that we must wear the hijab should be put to a Hobson's choice now? It's a Hobson's choice that either you educate yourself or you look after your conscience. Why? Is this fairness? Is this a state action? Guarantees the freedom which are guaranteed in the Constitution. And this kind of Hobson's choice, which is placed on the girls, my lord, should be disregarded. And then your lordship will see that this action, which is they have launched upon, is also opposed to fundamental duties of a citizen, guaranteed under Article 51A, and my lord is also shown and incorporated a statutory form in Section 7(2) of the Karnataka Education Act. Your lordship says Section 2, Karnataka Education Act. Your lordship is very familiar but they are actually reproduced in the Act itself. That, the Lordship may turn to subsection 7 of the Karnataka Act, and we say that the under subsection 1 may also include schemes in respect of and come to cross G. Clause G. 7 subsection 2 clause G. Inculcation of the sense of the following duties of citizens enshrined in the Constitution, namely, and then, my Lord, they are enlisting all the duties. And my Lord, your Lordship may see the Roman 5 to promote harmony and spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, regional, and sexual diversities to renounce practices derogatory to the dignity of women. So, my Lord, this particular practice, are we supposing to promote harmony or dissension on the basis that nor wearing particular hijab is disturbing us? Is it not a violation of the constitutional duty, the fundamental duty which is expressed in Article 51A? And incorporated, why is it incorporated by the legislature, my Lord, in subsection 2? And your Lordship has just section 133. In what circumstances section 133 can be invoked, my Lord? It is for the purposes of the Act. The Act is to promote harmony. The purpose of the Act is not to create a dissensions among the students. And when the established practice is there, then why should we have this kind of an attitude? Why should the school or why should the government come out with this type of an activity or this type of impugned sub-legislation? Then harmony, the spirit of common brotherhood, are we promoting that? Among all the people of India, transcending religious, linguistic, regional, social diversity, renounce politics, derogatory dignity. That is.
Yes.
Then my Lord, very next, value and preserve the rich heritage of a composite culture. The Constitution itself, my Lord, takes into account the diversity that exists in our country.
All right, Mr. Yusuf, we have understood what you are saying. Will you be able to finish today? Because now we are at the end of the day.
If your Lordship may give me some time tomorrow, I'll be happy.
Any other point to elaborate?
Yes, my Lord. The other point is very important point, my Lord, that it is also, my Lord, mainly referred to by Mr. Kamath in his, but he has not elaborated that proposition, the doctrine of proportionality. The doctrine of proportionality, my Lord, totally ignored. I will like to dilate a little, my Lord. I will not take much time. I will not repeat whatever my learned friends have said. I'm merely trying to elaborate some points that they have merely referred to. And I'm making a very important point.
That you elaborate in your written submission. Give the written submission, we will consider.
Your Lordship, give me 10 minutes more. I will just refer to it, my Lord. I'll just refer to it. Your Lordship,
yes, we have noted.
Doctrine of
proportionality. You want to elaborate on that? We have already noted it. So, if you want to elaborate it, give it in written submission. We will
then your
see
Lordship,
that.
either you give me 10 minutes today or you give me 10 minutes tomorrow. I will not go in detail on it. Because what is the doctrine of proportionality, my Lord?
What more you want?
Components, that I just want to read, my Lord, and I want to show to your Lordship a judgment of the Supreme Court, my Lord, in which they have shown what is meant by doctrine of proportionality and how that has been totally ignored here, my Lord. If your Lordship gives me 10 minutes more today or 10 minutes tomorrow, I'll finish it. And I promise your Lordship I will not, and as your lordship has been kind enough to give us the permission to put a written submission.
Finish your arguments today,
Lordship.
so that we may hear the other.
Your lordship. Much obliged, my lord. My lord, I will request your lordship to judgment. My lord, it is in the case of Modern Dental College and Research Center and others versus State of Madhya Pradesh, reported in 2016, 7 Supreme Court cases, page 353.
Yes.
I'm sorry, my lord. I request my instructing advocate, my lord, to hand over the copies of those judgments to your lordships, my lord.
Yes. Paragraph.
Your lord. Paragraph 59, my lord. It is at page. Paragraph 59. 373. My lord, at page 412.
Yes.
The lordship is a page, paragraph 59, my lord. I will skip it because it merely reproduce 96. The lordships are very familiar with it. Then, my lord, I read sections, sorry, my lord, paragraph 60, my lord, which is of utmost importance. Another significant feature which can be noticed from the reading of the aforesaid clause is that the state is empowered to make any law relating to the professional and technical qualifications necessary for practicing any profession or carrying on any occupation, trade, or business. Thus, while examining as to whether the impugned provisions of the statute and rules amount to reasonable restrictions and are brought about in the interest of general public, the exercise that is required to be undertaken is the balancing of fundamental rights to carry on occupation on one hand and the restrictions imposed on the other hand. This is what is known as the doctrine of proportionality. Jurisprudentially, proportionality can be defined as a set of rules determining the necessary and sufficient conditions for limitations of a constitutionally protected right by a law to constitutionally permissible. According to Aharon Barak, former Chief Justice of Supreme Court of Israel, there are 4 subcomponents of proportionality which need to be satisfied. A limitation of a constitutional right will be constitutionally permissible. It is designated for a proper purpose. Now, my lord, your first thing, your lordship, was our submission that this particular impugned action is not advancing the purpose at all. Purpose of the act. The measure undertaken to effectuate such a limitation are rationally connected to the fulfillment of that purpose. The harmony is the real purpose of the act. And the measure taken by them is go much against the provision of harmony and also the fundamental duties that are enumerated in the Article 51A. Then 3, measures undertaken are necessary in that there are no alternative measures that can similarly achieve the same purpose with a lesser degree of limitation. Now, why not, my lord, this? It's assuming that they want to have a uniformity, want to have discipline, then why not consult? Why not consult the people who are likely who are the stakeholder and who are the person like affected, whose rights are impacted? Sorry, that there needs to be a proper relationship. Proportionality is stricto sensu of balancing between the importance of achieving the proper purpose and a social importance of preventing the limitation of the constitutional right. What is the constitutional right, my lord, here, which are infected and infringed? Article 25(1), right to my conscience, right to my expression, my lord, right to have my education, my lord. That's totally disproportionate. Totally disproportionate.
All right.
This is the ground on which, my lord, we attack This in addition to all the grounds which are mentioned by my learned friends, the three of my learned friends who preceded me in addressing your lordship. And my lord, I humbly, my lord, thank your lordships, my lord, for inexhaustible patience in hearing this matter.
All
And
right, thank you.
your lordship will give me the liberty, my lord, to file my written submissions, my lord. My lord, your lordship may prescribe some time within which we have to give. And my lord, I want to
All
make
right.
clear, my lord, one thing, that these are all grounds which are advancing at a stage of interim stage. I think the hearing of the interim application is going on, and not the final hearing. There is some confusion in my mind, my lord. Your lordship may forgive me for putting it before your lordship. I
Yes,
think
what?
interim applications are not yet disposed of. So this is the hearing
Oh.
on interim applications. Otherwise, we would like to argue.
We do not know how you people have started arguing. We have started hearing. That is all.
What are we arguing? You know, because the lordship have already passed
I
some.
don't know whether you are making final submission or making your submission on interim relief application, because that has not been clarified.
Final, my lord. 10 hours your lordships have been hearing. It has to come to an end. It cannot go on.
And what are the interim orders? How is the
It has to be
interim
final, my
application
lord.
disposed of?
Your lordships have been
My lord,
so
we will
gracious
like,
in
we will like
giving
to
such
know
a
how
time.
the interim
Let it be
orders are
final.
disposed of, interim applications disposed of. Your lordship has granted certain orders.
We have not disposed of any interim relief application. Let it be very clear.
My
Okay.
lord, sir, hearing
So
is
we
final.
think, my lord, that these are the
On the first day, we had passed some
because we have to
interlocutory
establish
order.
only prima facie.
That is all.
At interim stage, my lord, we have to establish only prima facie case.
All right. We have heard Professor Ravi Verma Kumar in writ petition number 2347 of 2022. Mr. Yusuf Hatem Mukhalle, learned senior advocate,
Muchala.
has argued on writ petition 3038 of 2022 for the petitioners. Put up tomorrow. Now, put up tomorrow at 2:30. We'll continue. Now we are left with writ petition number 3148
Please.
of 2022. That is
Can
a
you permit
PIL.
to start with me, Lord?
3424 of 22. That is also a PIL.
Please.
This 3424 22. There are some office objections which have not been removed. So only two writ petitions have been left
Please.
to be heard on behalf of the petitioners.
Tomorrow I may permitted to start with me, Lord. So I'll conclude within 10 minutes, my Lord.
My lord, my petition 3418 is also complete. I have been waiting for
3148 is my petition.
3418. That's also complete. Is also required to be heard whenever your lordships will get time.
My lords, I'm party in person, Dr. Vinod Kulkarni.
Make one
PIL
submission.
is 3312.
One submission.
In 3 minutes, I'll finish off my submission, my lords.
In WP 2146, IA number 5 has been filed. Court may kindly recollect yesterday for some technical reasons it was not considered. A proper application has now been made. IA number 5, seeking a clarification, saying that its students will abide by the whatever uniform insisting upon. Just to use the same dupatta to cover the head. Only no additional dress or seeking a clarification. Let the students get back to the class.
My lord, I am a petitioner in person. My lord,
Just a
I am
minute.
Number 5.
Just a minute.
IA number 5 may kindly be perused. Kindly look at the
IA
page.
number 5 of 2022 in WP number 2146. Planet Advocate General, appearing for respondents, informed that he has received the copy of this application. He intends to file the objections to this application. He prays for is allowed. 2 days time to file the objections.
My
My
lord,
lord, before Raju, I make one humble
I'm
submission, my lord.
petitioner in person.
I connected to your lordship from Delhi, my lord. I have one submission. My petition was, your lordship was pleased yesterday to club my petition 3418. That was an order passed by your lordship. Whenever your lordship will get time after hearing other matters, my matter may be also. That's a separate.
Which is your writ petition?
3418 or 20222. Josefa is
Where is
title.
that?
Yes. 3418.
3148 hai.
Yes.
It
yes.
is 3148.
Yes, my lord. Josefa. Title is Josefa. Yes.
Yes,
Josefa.
we will hear you.
Please, your
My
lordship.
lord, I'm petitioning in person. I filed intervention petition in writ petition 2347 of 2022 today itself. So either I may be granted time or this is very small petition. In that we have given the reasons that it should be not allowed their petition. So those grounds we have pointed out in our intervention petition. So that we may be granted time or it can be read by the lordship. Today it was filed, my lord.
Written submission. What do you have filed?
Intervention petition, my lord.
Intervention applications will not hear. Sorry.
But
We'll
that
hear the
can be-
petition counsel
that can
only.
be my lord can read. The time may be not granted with the very material points for the assistance of.
If required only, then we will permit, otherwise not.
Yes.
Take it that we are not permitting anyone to intervene.
No, but that could be read, my lord, for the administration of justice. That lordship, that's a very small petition.
Now there's one IA filed by Mr. K. Kotwal, advocate. R. Kotwal.
Please, lords.
Yes,
Please,
you have
please,
moved an
lords.
application for impleading
Please,
as proposed.
I'm not pressing that application. I am not pressing that IA number 1, my lords. Since I have already
Because
filed one
what
more
we find,
PL,
we have also filed an
that may be
impleading.
heard.
Why not
Please,
cost
lord.
should
That
be
was I'm
imposed?
not pressing the IA
How
number 1 is
without
not pressed, lord.
86 है ना?
that IA 1 of 2022 in writ petition 2347 is dismissed as not pressed.
Please, oblige, my lord.
My lord, I stand corrected, but I do 3586.
Does not want to press this application. Dismissed as not pressed.
My lord, 3586 is my petition. Sorry, my lord. I stand corrected. 3586. 3586.
Yes.
Yes,
We'll hear you.
please.
We'll hear you when your
Please,
turn comes.
grateful. My lord. I'm highly obliged.
Lordship, may I make one submission, Lordship? In first two petition, state has filed objection, Lordship. Permission may be granted to me to file rejoinders, Lordship. Because some facts they have stated, I'll file written rejoinder.
Whatever you file it, nobody will stop.
My lord, I am Dr. Kulkarni, party in person in WP 3312. If you can kindly hear me for 2 or 3 minutes, I'll be obliged, my lords.
Introducing the Taco Lovers Pass. A taco a day for 30 days for $10. Only on the app.
ಕ್ಯಾಪ್ಚರ್ ಆಗ್ತಿದೆ ಸರ್, ಎಲ್ಲಿಂದ ಆಗ್ತಿದೆ ಗೊತ್ತಾಗ್ತಿಲ್ಲ. ಇದು ಬಂದಿದೆ ಸರ್, ನೀವು ಮಾತಾಡ್ತಿದ್ರೆ ಇದು ಕ್ಯಾಪ್ಚರ್ ಆಗ್ತಿದೆ. ಸುರೇಶ್ ಎಲೆಕ್ಟ್ರಿಕ್